Analogical reasoning in law. Examples. 1. We know that an employer may not fire an employee for agreeing to perform jury duty. It is said to follow that an employer is banned from firing an employee for refusing to commit perjury. 2. We know that a speech by a member of the Ku Klux Klan, advocating racial hatred, cannot be regulated unless it is likely to incite and is directed to inciting imminent lawless action. It is said to follow that the government cannot forbid members of the Nazi Party to march in Skokie, Illinois. 3. We know that there is no constitutional right to welfare, medical care, or housing. It is said to follow that there is no constitutional right to government protection against domestic violence. The process appears to work in 5 simple steps. 1. Some fact pattern A, the source case, has certain characteristics, call them X, Y, and Z. 2. Fact pattern B, the target case, has characteristics X, Y, and Q, or characteristics X, Y, Z, and Q. 3. A is treated a certain way in law. 4. Some principle or rule, announced, created, or discovered in the process of thinking through A, B, and their interrelations, explains why A is treated the way that it is. 5. Because of what it shares in common with A, B should be treated the same way. It is covered by the same principle. It should be clear that the crucial step, and often the most difficult, is 4. And often the most difficult, is 4. When lawyers say that there are no relevant differences, they mean that any differences between the two cases, 1, do not make a difference in light of the precedents, which foreclose certain possible grounds for distinction, or, 2, cannot be fashioned into the basis for a distinction that makes sense or is genuinely principled. A claim that one case is genuinely analogous to another, that it is apposite or cannot be distinguished is dependent on conclusion, 1, or 2, and either of these must of course be justified. A precedent can serve as either a rule or an analogy. It serves as a rule to the extent that it governs all identical cases. As an analogy to the extent that it is at least plausibly distinguishable from the case at hand, but potentially suggestive of a more general principle or policy that seems relevant to that case. Analogical reasoning can go wrong, 1. When one case is said to be analogous to another on the basis of a unifying principle that is embraced without having been tested against other possibilities, or, 2, when some similarities between two cases are deemed decisive with insufficient investigation of relevant differences. Analogical reasoning lies at the heart of legal thinking, and for good reasons. It is admirably well suited to the particular roles in which lawyers and judges find themselves, to a system in which heterogeneous people must reach closure despite their limitations of time and capacity, and despite their disagreements on fundamental issues. There is nothing static to the analogical process, it leaves room for flexibility and indeed for an enormous amount of creativity.
Like this video, hit subscribe, hit that notification bell for more videos on Canadian law.